Those of us who are not bad faith authoritarians, or their supporters, can breathe a sigh of relief. A relatively rare good decision from the regressively right-wing Supreme Court has at least temporarily blocked an egregious attempt by Republican states to rig electoral politics in their favor by compensating for their hilarious unpopularity and terrible record and terrible values and terrible ethics. Intrigued? Then click that like and subscribe and enjoy the video. So this particular video involves a bit of a trip down memory lane, hopefully a happy one, because right before the 2022 midterms, I was discussing what was then an upcoming Supreme Court case called Moore v. Harper, and I said that it was probably going to be one of the biggest Supreme Court cases in the history of this country, particularly if it went the way that many of us feared given the composition of the Supreme Court. It was going to be a bigger decision, I think, than the Dobbs decision, which overturned Roe v. Wade, which is pretty damn powerful. Now, what was the case about as a bit of a refresher? Well, it concerned North Carolina and the bad faith Republican Party, which has gerrymandered the hell out of that purple state to try to instantiate a Republican supermajority, and again, what is otherwise a pretty purple state. For every conservative voter, you can find a liberal voter, and yet Republicans have written the laws in such a way as to basically make a conservative supermajority in the state legislature, just as they did with Wisconsin, inevitable. That's how bad faith the Republican Party is. And the voting maps, which gerrymandered the hell out of the state, have been challenged and struck down by North Carolina's own state Supreme Court. And even the conservatives on that court, they were like, guys, this is pretty egregious. It's like you don't even want a fair fight. You're terrified of a fair fight. This map is too heavily biased. You need to draw a new map. And the Republican Party in North Carolina got pissed, and they appealed the decision, and it made its way to the United States Supreme Court. And many of us had our sphincters collectively clenched because, of course, the Supreme Court of the United States is comprised of a 6-3 regressive conservative supermajority, and many of those members of the court are really cool with bad faith right-wing attempts to rig electoral politics in their favor. They would never, ever, ever allow something from the opposite party, the opposite wing of politics, the left and the Democrats, but all too often they are gung-ho about empowering bad faith right-wing electoral shenanigans. And the notion concerned this idea called independent state legislature theory or doctrine, in which conservatives argue, listen, it's really up to the state legislature to draw voting maps. And instead of having checks and balances, which is a notion that we love in the United States, we say we're, the executive, the executive, legislative, and judicial branches, both at a federal level and state level, should be able to check one another, to impede one another. Conservatives in this regressively conservative supermajority in North Carolina say, actually, no. We should be able to draw voting maps in such a way that both state governors and state courts should not be able to interfere. We should have absolute uncheckable authority. Now, again, most legal scholars say that's ridiculous. Setting aside the case history, the case law, the fact of the matter is, just as a founding principle, we believe in checks and balances where no one has absolute authority in any respect. The president can interfere with the Supreme Court and Congress. Congress can interfere with the president and the Supreme Court. The Supreme Court can interfere with Congress and the president. And it's just how we're able to have some sort of at least tense equilibrium. So the idea that you want to basically give the Republican Party a blank check to draw whatever voting maps, literally whatever voting maps they want at any time, and there's no way to check that, that's ridiculous. Well, the case, Moore v. Harper, was finally decided upon by the United States Supreme Court, and the decision is good. Let's be happy with it. It's actually good. It surprised me. In a 6-3 decision, the Supreme Court rejected the independent state legislature doctrine, at least for this particular case. So let's read. Axios reports. The Supreme Court on Tuesday rejected one of the Republicans' most audacious attempts to control elections. In a 6-3 decision, the justices said states' election laws can be challenged in court, a rebuke to a burgeoning conservative movement that has sought to block the courts from hearing such cases. A group of North Carolina Republican lawmakers had asked the court to embrace a sweeping legal theory called independent state legislature doctrine. The theory holds, as we talked about just now, that state legislatures have total control over their state's election rules, including the procedures that govern presidential elections. Even if a state legislature does something that would violate the state's constitution, proponents of the independent state legislature theory argue the courts have no ability to stop them. So let me bring that back. Even if the state's constitution empowers the courts and the governor to be able to interfere with the legislature's voting map. Perhaps a governor could veto the map and then the legislature would have to override that veto, or perhaps a court can strike it down. Even if a state constitution expressly has that built in, which North Carolina's does, proponents of this theory just stupidly say, well, the state's constitution doesn't apply. Now, let's think about that. The Constitution, in our system of federalism, the federal Constitution is the supreme law of the land. It supersedes everything. State laws, local laws, other federal laws. But that's also the case with state constitutions. Within a particular state, if they have a constitution, it is the supreme law of that state. So even other state laws are inferior to it. But what Republicans and conservatives are stupidly arguing is in this situation, even if their supreme law allows for checks and balances, that the Republican legislature should be able to say no and just do whatever they want. Really stupid. The Supreme Court rejected that argument in one of the highest profile cases of its term, Moore v. Harper. The Constitution does not insulate state legislatures from the ordinary exercise of state judicial review, Chief Justice John Roberts wrote for the court's majority. So again, we went into the history before, blah, 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 which covers it. But guys, folks, this is great news, okay? Now, I want to be very clear. This does not vindicate Chief Justice Roberts for his dereliction of duty as the court's administrator in checking the corruption of Clarence Thomas and now Samuel Alito, as we know. This doesn't vindicate him. He's not the great ultimate arbiter of democracy. This man is a right-winger who is complicit morally in a lot of excesses and overreach during his tenure as Chief Justice, and this doesn't sweep it away. But in this one particular case, he and a few other conservative justices on the court did the right thing. And we should be thankful that this decision wasn't decided the other way. Now, I'll also point out that doesn't mean that somewhere down, this isn't like a criminal trial in which double jeopardy applies. It's entirely possible that a different case with a different set of facts, but ultimately the same notion, independent state legislature doctrine, can make its way up to the Supreme Court again a year from now, 2 years from now, whenever. So it's entirely possible that this may be decided a different way in the future. But right now, this is good news for democracy. It's good news for Democrats who eagerly want a fair fight, because we know we'll crush Republicans in a fair fight, which is generally often the case. It's really bad news for Republicans who, as a party, understand that they can only win the game of politics by rigging the game in their favor through gerrymandering, excessive gerrymandering, through suppressing voter turnout, voter intimidation, things like that. It's bad news for them, which is hilarious, and we should all bask in their misery. But it's also important that Democrats continue to win elections. We can't get complacent. The fact that for once this regressively right-wing Supreme Court did the right thing doesn't mean that they'll do the right thing next week or next month or next year or the next decade. We have to get Democrats to win every election we possibly can. We have to maximize eligible voter turnout. We have to campaign. We have to do door knocking. We have to canvass. We have to encourage voter turnout. We have to encourage people to not vote third party, to vote for Democrats, no matter how frustrated you may be, because we have to deny Republicans the opportunity to further court pack. Imagine another scenario in which Justice Kagan or Justice Sotomayor have to retire, and we have a Republican president and a Republican Senate who are able to fill that vacancy with yet another conservative, because you know they absolutely would. They don't care about balancing the court the way that many others, like President Obama, God love him, thought about doing. He and his liberal beliefs thought, well, listen, we have a relatively balanced court on my watch, and if I have a vacancy, I'll fill it with a moderate. That was the, let me be clear, Barack Obama approach to civility politics. Republicans don't adhere to that. If there's a vacancy on their watch and they have an opportunity to cram a young, aggressively, regressively conservative ideologue into that chair, they will absolutely do so. So again, let's breathe a sigh of relief. Let's be thankful, but let's also turn up, turn out. Let's win every single damn election possible so we no longer have to rely on Chief Justice Roberts and a couple of others occasionally doing the right thing.